Loud.
Okay. Yep.
Okay. Hey, this is Stefan Kinsella. Rarely do interviews of people. My podcast channel is just to collect my interviews with other people, but on occasion I talk to a buddy who's interesting. And this is how do you want to introduce yourself? Tufty the cat, David.
Well, I go by both of those names. I've been operating under the name Tufty the Cat for about nearly 16, 17 years, something like that.
Yeah.
Um, it was, I probably don't want to go into unless you really want to hear the story, but there's a story behind the creation of Tufty the Cat.
Oh,
Involves,
let's hear it. Let's hear it.
I'll do a sort of shortened version. There
Well,
was,
before you start, so you're a patent
yes, sorry.
attorney or agent in England, correct?
I am a qualified UK patent attorney and a European patent attorney.
And you
Two,
and I worked together on a project a few years ago, which didn't really sustain on fighting patents related to nChain and all this kind of stuff, Bitcoin and all this, right?
yep.
And now you're still involved in other things. Okay, so go ahead. Tell me
Well,
your.
it's what led on to that. What we started led on to what I ended
Okay,
up.
okay.
But yeah, the Tufty the cat name it's sort of taken on a life of its own. But I blogged for I contributed to an IP blog called the IPCat for a few years. It's quite well known in the field. Um, and there was a thing I saw on the UK Patent Office. There was somebody was filing we have these things called opinions. Patent Office opinions became a thing in the sort of late 2000s, where anyone could file a request for an opinion to the Patent Office and get an opinion on validity or infringement or both for £200 fee, and the fee is still £200. So a really cheap way of assessing a patent. Um, and one of these, someone requested an opinion on, I think it was infringement, and it was to do with a bird table that was supposed to prevent cats from catching birds. And I took one look at this patent and thought, no way. And I had a cat at the time called Tufty, and I thought, oh, well, I'll just for fun make a pseudonym of this Tufty the cat, and filed some pseudonymous observations on this bird table patent. Uh, and they took them into account in the patent office opinion that came out. I thought, oh, that's interesting. So I wrote a blog article for the IPCAT about that. And then Tufty the cat started writing more stuff, things that I thought, well, I don't want my name attached to this because I was writing under my name as well. I continued writing as David Pearce, but also wrote as Tufty the cat for things that I thought were, I don't want to be professionally linked to this, or it's just for fun, or I don't know. And so Tufty the cat ended up writing an amicus brief for a referral to the enlarged Board of Appeal at the European Patent Office on software patents. Just just for the hell of it, in my spare time, I did some legal analysis and wrote just a short few-page brief on this referral to the enlarged board because my interest was in software patents and still is. Um, and I was basically saying this referral is inadmissible. There's no deviation in the case law and blah blah blah. Um, and I was one of many. I don't know how many they got, 50 or so amicus briefs. It's quite popular at the time. This was 2008, 2009. And then wrote for the IPCAT blog about this, and there was a lot of it was a very well discussed issue at the time on software patents, whether they should be or shouldn't be allowed. We had the usual FOSS type people pitching in with their more extreme view. Well, similar to yours, Stefan, actually, there shouldn't be any patents in this field. Um, but I was more into arguing in terms of, well, on this particular issue, there's no justification for referral because the way that we assess software patents at the EPO was pretty well settled by that point, and that's all I was saying. And then I got the the reason that Tufty the cat then became, nobody knew who Tufty the cat was at the time, but then I got an email from Australia saying, "Are you aware that Lord Hoffman has been using your picture on a presentation that he's been making?" No, you know, Lord Hoffman was one of the senior member of the House of Lords, did several key judgments on patent issues over the years, and he picked up on this software patents referral issue and read my amicus brief and was sticking up pictures of Tufty the cat with his talk and saying how he agrees with Tufty the cat. He had no idea who I was. And I thought, well, that's quite funny. So again, useful ammunition for another blog article. And then he came to the UK, came back to the UK, and came to Birmingham and did that talk. So of course I went along, and then I outed myself at the end of the talk where he mentioned Tufty the cat and how he agreed with his analysis of the legal position. So I went up to him at the end and introduced myself, and it was just really funny. So he was like, you know, classic posh old posh boy going, "Oh dear boy, how lovely to meet you." You know, it was great.
So you mentioned Birmingham. I
Yeah,
assume you mean Birmingham, England,
Birmingham in the West Midlands in England. That's
and
where
and and
that's where
and
I'm
that's
at.
not what's the right way to pronounce it? Because I had some friends when I lived in London, and they would pronounce Birmingham in a strange way.
Birmingham.
They would say Broomy or something like that.
Oh, you call it Brum. People from Birmingham are called
I
Brummies,
Brummies. Okay, okay,
but yeah, it's Birmingham rather than Birmingham, Alabama.
exactly.
Birmingham, England.
If you confused me for quite a while, Broomy. I didn't know what they were talking about. So you and I were involved a few years ago in a project. You want to talk about that?
Yeah, well, I think that was 2021,
Something like
thereabouts.
that.
Um, I started taking an interest probably the year before then in this company nChain that was filing lots and lots of applications. So, um, and it was known that they were filing lots of applications, and you can see on the UK Patent Office website, you can see within a few weeks of an application having been filed, which is different to other countries actually. Unusual for the for
Let me pause for a second. So
Yeah,
we have a lot of listeners who won't know the details of how the patent
yeah,
law system works. So you're talking about, so there's a company called nChain,
yeah,
which is a blockchain or Bitcoin company with a connection to Craig Wright and these guys, right? And when you say applications, you mean that they were trying to file patent applications in different countries to try to get intellectual property protection on core aspects of emerging blockchain and Bitcoin technology. Is that correct?
yes. Sorry, I'm going several steps ahead. Let
Okay.
me dial back slightly. So yes,
Yeah.
I started looking at this company nChain that was started by Craig Wright, in conjunction with a couple of other guys who we might talk about, might not. But Craig Wright was chief scientist of nChain, so he was the guy pretending to be Satoshi Nakamoto. nChain was set up to commercialize Craig Wright as Satoshi and patent everything. Basically, that was what their business model was, and to some extent still is. So in early 2016, February or March, I think, they started filing applications at the UK Patent Office because they were based in the UK. So they started filing, and people soon started to notice that they were filing lots and lots of applications.
Yeah.
Um, what would it be? Maybe several a month, which is quite a high rate for a small company. Um, but
And just to clarify for to do this, you typically hire a patent attorney or a patent law firm, and you have to pay many thousands of pounds to do this, right?
yeah, that and clearly
It's expensive. Like we're talking what 10, 20,000 pounds per patent application per country, something like that, right?
uh, that sort of ballpark, yeah,
Right.
yeah. But in the first year, you just file one, then it balloons out into several other countries. You can file based on that initial priority filing. So at the start, they were just filing these priority filings, and they were using a well-known, respected firm in the UK, UDL, and no, that it was just the unusual thing about it was that it was a small startup company filing lots and lots of applications, an unusual amount. And they were all in this sort of blockchain area. No one knew what they were because they don't get published for 18 months until after filing. But there was certainly interest from the start, and certainly because Craig Wright was in 2016 becoming his story was becoming more widely known. There'd been the article, this sort of supposed outing of him in late 2015 with the article in Gizmodo where they were provided information about Craig Wright being Satoshi that turned out to be fake and probably came from Craig Wright himself.
Okay, it turned out to be fake. Let's so basically there have been some court decisions in the recent year or two
Yeah.
which have determined conclusively that what?
Well, in the court decision that really counts is the one that was earlier this year that issued the judgment issued in May this year from Mr. Justice Mellor. That's the case of Coper versus Wright. And basically it decided Craig Wright is not Satoshi Nakamoto. So he completely failed to provide any convincing evidence that he is. He filed lots and lots of things, filed lots and lots of evidence, but none of it was remotely convincing. Almost all of it was forged or at least manipulated. So he's, yeah, I mean, there's a permission to appeal pending, but it's fairly safe to say, in fact, it's very safe to say that Craig Wright has been shown in a court of law in the UK, he is not Satoshi. He is a liar and a fraud.
No, and I think the HBO documentary recently just proved it was some other guy, right? I'm I'm joking a little bit, but there was some HBO documentary where they concluded that some guy I'd never heard of is really Satoshi, which I don't think anyone thinks is correct, right?
Oh, they said it was Peter Todd. I mean, Peter Todd is well
Peter
known.
Child, that's right, that's right.
He's been around for ages. I mean, he wasn't, I think he said he wasn't there at the start, but he came in maybe a couple of years in. He was very young at the time that Bitcoin was
Right.
being created. I think he was at high school. Um,
So you think we don't know right now who Satoshi is, right?
um, no, we don't know. And there are strong candidates, but I'm at the point where it's sort of pointless to even ask the question because it doesn't matter anymore. It ceased to matter many years ago
Right,
when Satoshi himself decided to leave.
right.
And the reason for leaving was because Bitcoin is supposed to be decentralized and not under the control of any one person. So, yeah, to some extent, you shouldn't even bother asking. It should
Okay.
be necessary.
So back to your story. So you had these filings from nChain, and then what happened next?
I was just keeping an eye on them. I wasn't making a database at that point or anything. I just thought this is unusual. I'd like to see what they are when they publish, which they started to publish. That would have been 2017, mid 2017. They started to publish. So I may have had a quick look at them from that point on, but didn't really pay much attention until 2021. And lots of them had been published by that point. So I took a proper look at that stage and saw that they were doing the usual route of filing in certain countries. And because I'm a European patent attorney, I was looking at the European Patent Office, so seeing what they were doing there, and they were getting quite a few granted as well. So I started taking a look at, but what have they got granted? And there were some that I thought, okay, well, this is surprising what they were getting granted here. Some were they were
Why do you say surprising? Do you have like a background assumption of competence among the,
well, the European Patent Office examiners are generally pretty good. Um, they, but when you've got a new technical field that they're not used to examining, and Bitcoin blockchain is still, well, certainly was a few years ago, still fairly new technically, although lots have been published about it. They might not be looking in the right places initially, so I think it takes a few years for these this
okay,
expertise.
but do you think that it's possible to have an objective, fair government bureaucratic procedure to examine an invention that's filed, whether it's really novel and non-obvious or inventive? Do you think it's really even possible?
They make a pretty good stab at it. I think the EPO is it's fairly good. I mean, they don't always get it right, and
But how could you know? How can they know? How can you really know the prior art? And how can you know the standards? Like what is so in the US, it's to get a patent, you have to have novelty and non-obviousness. In your country or in Europe, I think it's called inventive step.
yeah, it's the same. It's the same thing. Same thing.
So how can there be an objective determination of an inventive step, which to my mind means knowing what is known in the prior art now, would a fairly smart, inventor be motivated to combine these things to come up with the next solution, which they're going to file a patent on, right?
Well, that was one of the issues that the European Patent Office had a problem with early on, and they because it's very German in its procedure. Um, it wanted to
And
develop.
it's located in Munich, correct?
Well, there's Munich and The Hague are the two main locations. Munich
Yeah.
is the headquarters.
Yeah.
So yeah, it's very German led. And the Germans like their structured approach to things, uh, without being too um, uh, what's the word? It's not. I'm not saying this is typically German. It's just that is what the German approach tends to be, more structured. So they wanted a structured approach to how to assess inventive step, and this is back in the early 80s, I think. So the Board of Appeal at the EPO developed what's called a problem solution approach to assessing inventive step. So this is supposed to take out as much of the subjectiveness as possible, really, from the assessment of, well, does this have, if you've already assessed novelty and you haven't found all the features in one document, and it's almost always documents, then you look at the features that are missing and you go, well, okay, well, first we need to find what is the closest prior art, and that's usually the document that has most of the features that you're claiming in your claim one, to a first approximation. And then you go, well, what features are missing? And then can you find those features in some other document or some other source?
Yeah.
And it's almost always two documents that they're weighing up. There are complications, but if they say, well, what is that missing feature? What's the technical effect of that missing feature? And then you turn that around and say, how could we say the objective technical problem to be solved is? So we ask the question, how do you achieve that technical effect is usually how you put it. And then you go to the other document. Does that document solve that technical problem? If it does, then in most cases it's obvious to combine them because that problem has already been solved. So it comes from the premise that all inventions are about solving technical problems. So from the European Patent Office point of view, you always have to show that what you've claimed solves a specific technical problem. Certainly if you're arguing inventive step.
But you can see, okay, and I'm a libertarian, and the audience will be libertarian. You can see that you could have a set of rules that will tell bureaucrats in a government office what to do,
Yeah.
but they have nothing to do with justice or with rights or objective law or anything like that. So yeah, sure, you could have a flow chart that says, okay, if you're an examiner, you get a patent application submitted to you, you have to compare it to the prior art that you can find and the other things, and then you compare it and you make a subjective determination about inventive step, and then you make a decision, and then it goes forward, which, by the way, is why lots of the Craig Wright or the nChain patents were being granted, is because these standards, in my view, are completely non-objective and non-reality based, and they're
Uh,
just some bureaucrat following a standard set down by a legislature. Has nothing to
yeah,
do with justice or reality.
there is though on nChain's patent applications, there is a specific issue why these are being granted more than you might expect at the European Patent Office, and it's because although the European Patent Convention says certain things are not considered to be inventions, which includes computer programs and business methods, they they have a kind of exception to those exceptions, as it were. And one of those the main exception is if you can show there's a technical effect to that. So the usual example would be a new program for a washing machine. So if you can program your washing machine in a particular way, and all you're doing is changing the software, and somehow you make the washing machine more efficient, or the clothes are cleaner, or something you can tie to the real world,
Yeah.
then you can argue for a technical effect. But if it's just computer software, if it's data in, data out, then normally the view is, well, there's no technical effect because it's just data in and data out, and there's nothing more than a computer software program for a computer. But the over the years, the boards of appeal at the EPO have kind of carved out certain areas that they say, well, this bit's okay. So there was a very early decision about image processing. So although data in, data out, if you're not saying this data is anything meaningful, if it's related to an image and the output of that computer program is the image becomes sharper, I think it was, then that's a technical effect. And then you can get a patent for the software. And there are lots of things like that that carve out exceptions to the exceptions of computer programs not being patentable. And one of them is in the field of cryptography. So if there's an improvement in security, for example, um, or yeah, security generally. So anything that sort of relates to cryptographic processes um, generally gets a free pass and is just argued on the usual novelty inventive step grounds. And of course,
So is that equivalent in the US? We would assume utility, like we would assume that it works as useful.
kind of, yeah, yeah. I suppose it'd be equivalent to that. So they say, yeah, we're not going to look too closely at this being clearly just a computer program
Right.
because it's in this subset, this field of cryptography, which Bitcoin and blockchain, it uses cryptographic methods, so generally will not be excluded, or the European Patent Office doesn't tend to raise objections on those grounds. So that's partly why nChain have managed to get so many granted, even though almost all are just computer software. And they've got granted because there's some cryptographic procedure in there that a European examiner will go, okay, I don't need to worry about raising an objection on patentability. Just
So let's talk quickly about back in 2020, 21, you and I became involved in the Open Crypto Alliance, and our goal was We
Be careful not to call it the Crypto Open Patent Alliance.
open, I think our name was the Open Crypto Alliance at first. I don't know.
Crypt,
Am I right?
something foundation in there as well, wasn't it?
Well, we changed many times, but the point is we got together because we were concerned about intellectual property claims, mainly patent, but also, well, our remit wasn't this, but like nChain and Craig Wright's uh, trademark and defamation and copyright claims too about the white paper and things like that, but basically patents and things like that. And our thought was we could fight this by having a council and we could have experts like you and me and donors and things like that, and we would debunk these patents one at a time. But the
Mm.
problem, of course, is that as you said, you're going to have dozens or hundreds of patents that come out. And even if we had a success every now and then, we could debunk one patent. The way the patent system works is it's an extortionate threat where you can use a patent that's pending or issued to extort or to bully people. And so unless you could get rid of all of them, like it's a futile battle. The cards are stacked against us. That's how I saw it. And that's why I think ultimately the Open Crypto Alliance failed because the strategy is just not going to ever work. You can never have enough resources to debunk the patents issued by government agencies around the world, which 90% of which are probably bad, but that's the way the system works. I mean, what would your perspective on that be?
Yeah, it is. Well, as I've learned over the last few years, it is a kind of whack-a-mole.
Yeah.
Um, for a company that is well resourced, they can keep on filing applications, even if you manage to knock one out. They might have another one. You call them continuations in the US. In Europe, we have similar process where you can file divisionals, so you can keep things going. Even if you knock one down, another one can pop up later. Um, and also, if you file as many as nChain have been filing, it's impossible to know which ones might turn out to be important, which ones might end up being infringed by someone, even though they may well be invalid, whether they're even going to start threatening people. I mean, I've not seen any, I should make it clear that nChain have not been threatening anyone with patent infringement. There's been various noises from Craig Wright over the years of such and such infringes my patent on this. I think he's said that several times on several different patents, and I've taken a look each time whenever he's been specific and thought, no, really? So yeah, if that's why the sort of model of, well, let's go knocking these things down. Um, if you've got, what have they got now? The current count just in Europe is over 130 patents, just from nChain.
Well, I mean, I think if one of us became a Bitcoin billionaire, maybe we could have a fund and we could just spend our lives knocking down nChain patents. But even
Well,
that wouldn't work because half of them would be presumed valid and they would still exist, right? They could still be threats.
yeah.
Okay, sorry, we were saying, keep going, sorry.
Uh, I forget where we got to now.
Well, okay, so let me ask you this. So you're a European patent attorney.
Yep.
You must have some. Are you a libertarian? Do you have libertarian inclinations? Why are you interested in this injustice caused by the patents and the Bitcoin system and all this stuff?
Well, I was more interested in how Craig Wright was getting away with it, and thought, well, surely these patents. It wasn't as broad as you might put it, being a libertarian. I'm certainly
Right.
more of the libertarian than the left-right axis. I'm more orthogonal to that. Um, but I was just interested in, how can someone who's clearly not Satoshi be getting patents granted on fundamental
Okay.
parts of Bitcoin. So
But 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 did that make you did it make you rethink like the system is not just, not fair, something wrong with it? Did you reconsider the whole thing or what is your current take about, and you know my view, I'm a
yeah,
libertarian. I think the whole patent system should be abolished. Like, is your view just more mainstream? Like, I think we should have a patent system, but it should be better run by the government, or what?
I well, I'm not going to come out and say all patents shouldn't be allowed because my livelihood depends on it. So, but I do think that the system can be um the if the system's going to work, there should be checks and balances, and we should be able to point out where the system's not working properly. And generally, yeah, it kind of does. Although, I mean, and the as we might get onto, the European opposition system is a good way of giving everyone else a chance at knocking invalid patents down. Once they get past that, it can be very expensive to knock patents down. And I know in the US, it's much more expensive at all stages to knock an invalid patent down. But I think the system generally works fairly well in Europe, and I mean, without being putting my patent attorney hat on and saying I'm only saying this because I'm a patent attorney. I think the system does work, and I wouldn't want it abolished.
Okay.
Um, but once I've retired, I might say something different. Who knows?
Well, my view as a libertarian American patent attorney, I think that the reputation of the European Patent Office is that it is more competent than the US one. I don't know why. Um, but to me, that's like saying that you guys do socialized medicine better than we do. Okay.
Well, we do socialized medicine in the UK, but we're certainly not very good at that. They're better at it in other European countries, I think.
Yeah, but you may be better at it than the US hybrid system where we have half private, half socialized. It's like, I'm not sure which one is actually better. Um, at least you get something for your money in Europe, whereas here it's a hodgepodge. No, so I understand the I'm not trying to pin you down. I'm curious about you have some interesting alliances, put it that way, with me and people like me. Um
Well,
there
it's
must
more,
be. Mm.
yeah, it's more in a specific technical area, and probably goes back to 20 years ago. I went to see Richard Stallman lecture in London, and he's a brilliant, I mean, crazy guy, but brilliant public speaker. And it was at the time where software patents were a big thing, and I thought I sort of could see both sides. I mean, I was learning patent law at the time, doing an MSc, and then before I became a patent attorney, and that kind of stuck with me. So I've always had some sympathy with the FOSS type argument,
Yeah.
where software should be free and shouldn't be patented. I can see that being a valid argument. Although I do patent applications for software, computer implemented inventions all the time, but I don't put my view on them. I just
Well,
get.
let me ask you. So are you independent? Are you with a firm? What is your actually career path right now?
I'm with a firm called Barker Brittell in Birmingham, in the UK.
And so you are have you ever gotten any pushback from your unorthodox opposition to aspects of patent law or abuse or whatever, or no one cares?
Most people don't even pay that much attention, but I don't think I'm particularly unorthodox. I make my views known, but usually that's views are like my views might be, well, this judge got this particular decision wrong, um, which is fine, and we're allowed to disagree on points of law.
Right.
Um, or this particular Board of Appeal at the EPO got it wrong, or as we might get onto, this patent shouldn't have been granted.
Well,
Um,
the reason I ask is, I mean, early in my career, starting in 1994 or so as a patent attorney, I was reluctant to be forthright about my growing anti-patent views because I thought it would hurt me with my law firm or with my clients. But over time, I realized no one reads anything. They don't care. If you have a strong opinion about something, even if they don't agree, they assume you know what you're talking about. So they think it's a sign of it's a credential, right?
Yeah,
So
but
over time, I learned to get over that.
I was I don't have anti-patent views. I've never said I don't agree in the patent system with the patent system at all. But I've been quite strong about certain views of patent law, and I've been on a last year I was on a panel for the 20-year anniversary of the IPCAT, and I was on the panel with Sir Robin Jacob, who was a Court of Appeal judge for many years, very well respected judge who ruled several times on computer software patent cases, and I my point, only slightly jokingly, was that I thought one of his decisions was the worst one of the last 20 years. But he took it in good humor. It was fine.
But when you say you think the system works fine and the European system, are you speaking just like a mainstream citizen of the world that thinks legislation works and democracy works and we have to have give and play and tug and all this? And I mean, do you really believe? And you said you wouldn't favor abolition as you're working, which I understand.
Mm.
But do you really believe the ultimate claim of people behind the patent system? Do you really think that their claim is true that the patent system incentivizes innovation? Do you really actually personally believe that?
I think it's questionable in certain areas, in certain fields. I think it can be more of a, a harm to innovation in certain, if patents are not used if you're used in a particular way. Um, in some areas, they might be more beneficial. Although even then, it's because I work in particular fields, I can see arguments to and in favor and against more in certain fields than in others.
Do,
So
do you,
like I was saying, I'm not sure. I'm not sure whether patents are the right sort of thing for a lot of software inventions. But then there are certain software inventions where patents are the right thing, and I could argue that in certain areas, but in other areas, I mean certainly on patents for Bitcoin, I would say absolutely no, because Bitcoin is
well,
established.
let's get into that. So tell me what you think is the main threat by nChain or by anyone else using the patent system to attack the crypto ecosystem. Like, what is the main threat to that in your view?
I think the threat, and it's not been proven yet because they've not tried to assert any of these patents, but the main threat is asserting invalid patents against people just working in the field, or companies working in the
Okay, but
field.
hold on. What would a valid patent be? Do you think there could be a valid patent where someone could own the entire infrastructure for to
Then
blockchain?
then we then we have to get into, what assumptions do you take from what nChain has been doing since 2016? Now, we know for a fact that Craig Wright is not Satoshi, so therefore he had no particular special knowledge relating to Bitcoin and what direction it should be developed in. So I would say it's a fairly safe assumption that any of Craig Wright's inventions are going to be pretty much worthless because he has no special knowledge. So it's very, very unlikely that he's going to have come up with something that then later on turns out to be essential in some aspect of Bitcoin.
And yet the European Patent Office and other patent offices
And yet,
are
and
granting any of these patents.
that's where the slight danger is, because there's still a chance of them getting patents granted at the European Patent Office for aspects which turn out to be part of the prior art. And if they start asserting those, they can cause trouble. But that's like any patent troll. Patent trolls generally assert patents that have dubious validity that in the US especially have been amended in a way that kind of gets them onto the thing that they want to infringe, even though the original filing was nothing like it. That's much more difficult to do in Europe.
Well,
But still,
let me ask you this, as an attorney and as someone who's following all this, what is the legal implication of the fact that Craig Wright has lost in many legal tribunals, and he's been declared not to be Satoshi? What's the implication of that for his patent filings and his defamation claims and his trademark claims? How do you think, because he apparently keeps going with
yeah,
bullying, threats, and extortion attempts?
the as I've said before to on other interviews, it has no effect on the patents themselves because they're not in his name. He's just a named inventor on lots of them. The validity of those patents is irrelevant to the identity of Craig being Satoshi or not.
But why does he keep going? Why doesn't his law why don't his losses in court smack him down and say you can't keep threatening people with these IP claims?
Um, well, that's happening. We can get into that if you want. That's happening this next month. So what happened in the big case, the Coper and Wright case, was the outcome was Mr. Justice Miller said, "You're not Satoshi." But also there was an injunction that came out a couple of months later that had several things in it, which is one of which was basically you're not allowed to sue anyone on the basis of that you're Satoshi, but also you're not allowed to sue anyone on the basis that you, Craig Wright, own goodwill in the name Bitcoin, for example. So passing off
When you say not allowed to, you mean in the UK or where?
anywhere. I mean, I could. Well, that's
How,
not that
how, how could a judge in the UK affect the legal system in another country?
because it's directed at Craig Wright himself. So if he breaches that order by suing anyone anywhere in the world, he's in breach of that under UK law. So UK law would pull him back in.
Mm.
And so that injunction was pretty broad, and it wasn't just injuncting him against issuing or threatening proceedings on the basis of him being Satoshi, but it was also saying you're injuncted against threatening or issuing proceedings on the basis that you, Craig Wright, own goodwill in Bitcoin or own copyright in anything to do with Bitcoin or database right in anything to do with Bitcoin. And so it was pretty clear and pretty broad. And yet he's filed this new case last month, which he calls his champagne passing off case. And he's literally claiming to own goodwill in the name Bitcoin and literally claiming to own database rights in Bitcoin. So he's clearly in breach of this order and therefore in contempt of court. And that's going to be,
So what do you think will happen?
well, there's going to be a hearing next month um, on this contempt issue. So the him filing this new passing off case triggered the other side, Copa, to file for contempt of court proceedings.
And why do you think he's so stubborn or so intransigent? I mean, why would he do this if it's
I,
futile?
I don't know. I cannot fathom his thinking on this, but he seems to be just driven by some sort of madness that he's always right and he can never back down. So, or maybe he just didn't read the order. I don't know.
Can you explain what COPA is? So we talked, you and I were a part of the Open Crypto Alliance, and now there's COPA. Can you explain your relation to them and what they're trying to do?
Well, COPA is the Crypto Open Patent Alliance. So
Right.
that's is it a consortium or alliance? Well, it's an alliance. It has various members, including I think Jack Dorsey is basically the lead guy on that, and he's got companies like MicroStrategy, so Michael Saylor and various others joining forces, and it's sort of a it's not really a patent pooling system, but it's a defensive patent pool. So all the members of COPA um, don't they don't give their patents to COPA, but they agree that if any member of COPA is sued, then they will use their patents defensively. So they'll go after who's suing them on whatever ground they can find with their patents. Now, I don't understand the details of how that can work in practice, but that's the basic principle of how COPA is supposed to work. Um,
Are you not part of COPA, or what's your relationship?
no, I'm not part of COPA. I get accused of being an advisor to COPA or member of COPA. I'm not a member of COPA. Um, I'm not paid by them. I'm not. I don't advise them. I'm not part of the gang. I'm sure
Well, the question is, why not? Why aren't you and I part of COPA?
they haven't asked, and they're not in the business of attacking patents, which I don't know, that kind of initially surprised me because I thought, well, you've got this rich seam of patents being granted that many of which surely must be invalid. Surely you should start going after them. But as we were talking earlier, what's the point? There is limited point at going after all these patents when it's just playing whack-a-mole and spending lots of money on expensive patent attorneys. So they haven't taken that line yet. They might do at some point, and
Could
I'm
be.
ready to help if they do, but I haven't been asked.
Okay. Interesting. I mean, we talked a little bit about policy, and you're not one of us really, but you seem to be like one of us in common sense, in the sense that you don't want to attack the bread that butters your plate or whatever you call it. But
I suppose, but yeah, I get what you're saying. Yeah.
yeah, it's a bad metaphor. But from your point of view, if the current patent system of the world order, the US led, the European led, the treaty system, if the patent system disappeared tomorrow, do you really personally think that the world would be worse off? We would have less innovation, pharmaceuticals, whatever. I mean, do you really think that? Or can you not say?
Well, it's impossible to say.
Right, but what is your gut? What
But
is your opinion?
um, where we are now, lots of businesses do depend on having patent protection.
Of course.
So if that patent protection was immediately taken away, they they would be in trouble. But then if you took all patent protection away immediately, then there would be a big crash, and then things would rebuild in a different way.
So you think that if this happened, we don't envision a world, let's say 10 years from now, we get rid of the patent system. You don't think we would have a world where there's no innovation?
No, innovation would still happen, but I think in a different way. People's behavior would change.
Correct.
I don't know how that would work out, but yeah, I can see that there are incentives built into the system um, to get patent protection so that you can then get investment, and that investment wants to come in because if it wants to kind of have insurance on against competitors coming in. So patents are used in that sense a lot.
Well, let me ask you this. So you're a patent practitioner like I am. There's in America, there's patent attorneys, patent lawyers, patent people that depend on this field. I understand all that, the economic incentives. Um, would you agree that like in law school or in your profession, there is no clear evidence that the patent system actually does what it says it's going to do? I mean, do you think that you have any clear empirical evidence that the patent system benefits humanity?
Well, it's like people being taught economics at university. They get taught Keynesian economics,
Right.
certainly in the UK. They never get told Austrian economics. Um, and in the people training to be patent attorneys, like me, we go. It's much more procedural. You get to learn the law and the process, and there's no. Well, I've never had, and I did an MSc before I got my job as a trainee patent attorney. There was no real discussion or analysis of, should we even have patents?
Right.
I think the most we had was this one of the reading list on the trademark part of the course was a book by, is it Naomi Klein? Bloody awful book. No logo. Yeah. And that's very anti trademarks. Um, but that was as far as it went, and it was a terrible book anyway. So there wasn't the sort of philosophical discussion of, well, what are patents useful for? It's, I've never had that.
But the point is, your fellow and my fellow IP practitioners, we have no special expertise in knowing what the law should be. Would you agree with that?
What the law should be. It's more how the law should be applied. That's certainly how I view it. You know,
Well, what I mean is, if you take a typical patent attorney or a technical expert, who has an opinion about, oh, I think innovation is a good thing, and we ought to have a system that rewards innovation, blah blah blah. The
yeah,
typical arguments for IP.
yeah.
Do you think that they really have any idea about empirics or what they're talking about, or are they just repeating slogans? Like, do they really have a reason to say that, oh, if you get rid of the patent system, then society will collapse tomorrow? Do they have a reason to say that, or are they just like talking shit?
I've not seen good arguments either way, really.
Right. So, right. So there's no good arguments either way. So in other words, we're operating in a vacuum in a sense. Like we're just like going with the status quo. Like we have the system,
Yeah,
let's keep it
yeah.
going.
I mean, that's that's what I do day to day. It is what it is, and then we work within the system. Um, and sometimes we see things that don't look right. But we're still working within the system to maybe attack a patent because it doesn't comply with certain features of the law.
Got it.
But
All
that's
right. I'm going to let you go, but is there anything else you want to add, or what are your thoughts on Bitcoin right now and the prospects of Bitcoin?
on the prospects of Bitcoin. Well, we're pretty positive at the moment, aren't we? We're 6 months from the halving, so it's going up, and yeah,
Oh, the last halving. Yeah, yeah, that's right.
yeah. The halving was in April, I think.
Yeah, yeah, yeah.
But yeah, on the last 2 or 3 cycles, it's started to go parabolic about 6 to 9 months after the halving, and we're kind of on track for that. It might all end tomorrow, but who knows? I don't think it will. It's looking pretty strong at the moment.
Are you a Bitcoin maximalist, or what are your thoughts on that?
Like a lot of people that are into Bitcoin, you go through it on a journey. So over the last few years, started looking into Bitcoin, and then of course you start looking, well, what's this other thing over there? What's Ethereum? What's Solana? And then you realize, God, there's 10,000 of these things.
Yeah.
And gradually you come back to the realization that the only one that actually really matters, that has the balance of things right and was happens to be the first one, is Bitcoin.
Well, you mentioned earlier Austrian economics, and I don't think you're one of us exactly. but you
No,
have enough
no.
awareness to mention it. So tell me, what is your interest in and your thoughts about Austrian economics and money and that kind of stuff?
I think I probably started. Uh, it's probably just from reading Seyfedin's book that got
Okay.
onto that track. So I've read all his books, the Bitcoin Standard and the Fiat Standard, and
And you mean Safety Moose, the Bitcoin standard
yeah.
listeners. Yeah. Right.
So and then that gets you into thinking about economics in a different way. Not that I've really thought about economics much.
So from your point of view, reading Seyfedin's book opened your mind towards, I don't know, libertarian, decentralist, money,
Yeah,
all these things.
yeah. I'd say that. That was probably the trigger, like with lots of people. I mean, he's sold many of those books. So yeah, it got me thinking and reading more different things. I've read quite a few books. Some of them are up there behind me. Um, so yeah, I'm certainly leaning more the libertarian Austrian economics view towards these things, uh, and definitely away from the conventional Keynesian view. And that all that points towards, um, the idea of money and state should be separated, really.
Wow. I think that's amazing. I think it's amazing that, I mean, mainstream guys like you, kind of conventional guys that just have common sense, like are learning about sound economics and political philosophy from a book explaining a new phenomenon, right? Bitcoin.
Yeah.
I think it's crazy.
Is it? Well, maybe it's just me, but I tend to on a few subject areas I get in I go in and I go in deep for a long time, and then after a couple of years I might have a new interest. So it's still with Bitcoin for now, but let's see let's see where we are in a couple of years.
Well, I'm going to let you go. I've taken up too much of your time. If there's anything else you want to say at the end, go ahead.
I would just say watch this space for what happens to Craig Wright in the next month. I'm quietly confident that something big will happen in before Christmas. I've also got my third opposition case. We haven't even got into that. So I filed with Arthur Van Pelt 3 oppositions on nChain patents.
You want
And
to talk about that? If you want to talk about that for a few minutes, go ahead.
yeah, well, after the thing that we were both interested in for a while sort of went away or faded away, um, I kept looking at what nChain were doing and came across one that I saw was obviously invalid. Don't need to go into the reasons why, but I thought, well, if someone wanted to file an opposition, this would be an easy target. Um, so I just asked Arthur Van Pelt, who's well known in the field, and he's sort of Craig Wright's nemesis, if he'd mind being the opponent, and I would write it. He could be the opponent, and all we'd need to do would be to get some funding to pay the opposition fee, which is like
How,
900.
how, how how is he the nemesis? In what way?
Oh, he's the amount of stuff he's written about Craig Wright. He's written loads over the last few years, um, detailing.
Has he been subjected to defamation threats and that kind of stuff or not?
Oddly, he's never been the target of legal threats from
Okay.
Craig Wright, um, unlike Peter McCormack and Hodlonaut, who were sued.
Right.
Yeah, I think Craig Wright's always been slightly afraid of Arthur.
Okay.
It gives that impression anyway. But yeah, Arthur agreed to do this and crowdfunded some money to pay the opposition fee, and we ended up getting enough money to pay for 3. So we ended up filing 3 oppositions against the 3 of the same sort of family of patents that had been granted. Um, and we got the first one revoked, or not even revoked, but they revoked it because they didn't want to go to the hearing. So they requested it to be revoked because they could see it was invalid. The second one, we had a hearing and got that revoked. The third one, we've got another hearing next month, and I'm pretty sure that's going to be revoked too. So we're playing really. This is only 3 out of 130 odd. and I've just been doing it in my spare time. But it's been
So,
a
so do you think you're on Craig Wright's enemies list?
yes, absolutely. And he doesn't like me at all.
Explain, explain.
Oh, well, I've I've been when how long do you want to go on? I've been specifically targeted by Craig Wright and his minions. I got into a bit of trouble last year with the regulator because they filed a complaint against me. Um, he's also mentioned me in one of his recent tweet threads, mentioned me specifically as basically accusing me of corrupting a judge. So because I've met Mr. Justice Mellor before, um, he's accusing me of I don't know, some sort of I've bribed him or blackmailed him or corrupted him in some way. I don't know. But it's sort of suggesting that there's something untoward with me and Sir James Mellor.
Well, is there anything that people that are supporters of Bitcoin and are aware of the threat of Craig Wright and nChain and their patent system, their weaponization of the patent system and copyright and all that, anything they can do to help, any kind of contribution or campaign or anything they could do to join
I don't.
in?
I think it only becomes serious once there are actual threats or
Okay.
procedures issued. So I think the best thing we can do is just, I mean, blowing my trumpet. I'm out there. I'm known by various fairly high profile people in the Bitcoin space. So I'm known as the guy that knows about nChain's Bitcoin patents, and I've knocked a few of them out. So if they do start properly threatening, then maybe they could come to me, put it that way.
Okay.
But there's lots of other people they could go to.
Got
So
it.
it's I think knowing what they're trying to do, not being too threatened by it unless there's something specific, and knowing that there are things that you can do if someone is threatened. So it's just awareness really, education and awareness, um, and wait and see what happens.
All right. Well, I appreciate your time and thanks for talking with me and keep up the good fight.
Thank you.